Hello and welcome back to At Your Pace Online's Michigan Real Estate Education Series. In this class, we'll dive into environmental issues as they relate to the real estate market. This class is going to spend a lot of time on law and legal topics. So we'll start by setting up the foundational real estate concept that the rest of the class will be built on. From there, we'll talk about pollution and waste. Then we'll examine Michigan's Natural Resources and Environmental Protection Act, also known as NREPA. After that, we'll get into the role and responsibilities of property owners and prospective buyers with regard to hazardous waste, pollution, and other similar issues. We'll close out this class with a discussion of brownfield reclamation. In today's age of concern about greenhouse gases, carbon footprints, and global warming, green buildings and other green technologies are the most common thoughts people have when they hear the words environment and real estate in the same sentence. However, when we talk about environmental issues and real estate, we aren't talking about preventing future harms. We're talking about issues related to harms that have already been done. These existing harms have several impacts on real estate markets. These impacts include impacts on the rights, responsibilities, and liabilities of both buyers and sellers, negative impacts on property values and neighborhood stability, and positive opportunities for innovation and redevelopment. Pollution and waste happen. Industrial production is rarely clean or waste-free. Former property owners don't always clean up the waste they produced. Sometimes neighborhood property owners can't or won't contain pollution they generate. And sometimes pollution and waste drift onto other properties from somewhere else entirely. Point being, you may find yourself having to deal with pollution and waste when you interact with a property. While this can be a problem for use and enjoyment, there's a whole legal side that is in some way even more important. As opposed to criminal law or contract law, environmental common law is almost all tort law. A tort is any action that one person takes that directly or indirectly harms another person. In this case, the harm treated under common law is usually pollution of air or water. An overwhelming majority of the body of environmental common law deals with the common law tort of nuisance. This has also served as the basis for much of the currently existing environmental legislation. Other aspects of common law that make an appearance with environmental issues are the common law concepts of trespass, negligence, strict liability, and the intersection of trespass nuisance. We'll examine each of these concepts later. Dealing with pollution, waste, and contamination can be very complicated. In order to be able to guide a client through this kind of situation, you need to have a grasp on the core legal concepts and procedures. You'll need to know how to advise a client on their options for responding to contamination that's caused by someone else. You'll also need to know how to advise a client who's being accused of contaminating another property. The information contained in this lesson is only a summary and overview of what are, in fact, several hundred pages of environmental law. This lesson isn't intended to offer either the final word in Michigan environmental law or a complete and thorough description of the topic. You should take the time to review this material in detail for your own benefit and for the benefit of your future customers. Okay, we're going to move forward to talk about common law concepts. We're also going to establish the basics of federal and state environmental laws.